A new Human Rights First report documents how federal courts are the most effective way to prosecute terrorism cases. Richard Zabel and James Benjamin, the authors of this report and two former assistant U.S. attorneys, examine terrorism cases that have actually been tried in federal courts to assess the strengths and weaknesses of existing courts in trying terrorism.
What we did was we undertook to identify and closely analyze every single terrorism case that's been brought in the federal courts since 9/11, as well as a number of the very important terrorism cases that were brought in the years leading up to 9/11.
We ultimately gathered 123 cases and that we looked at that fell into our definition of Islamist, extremist, or terrorist cases.
We then looked at a whole series of procedural questions that tend to come up in terrorism cases. One of the most important of which is this criminal justice system capable of handling the problem of classified evidence, sensitive intelligence evidence sometimes that could, if revealed, jeopardize national security?
Overall conclusion was that when you study the record of these cases in the federal courts, and it covered approximately 15 years, what we looked at, that the United States federal courts are very well equipped to handle terrorism cases.
One very important implication of the paper is that the need for some brand new court system is not so apparent when one considers the ability of the existing system to do the job pretty well.
And by no means do we conclude that the criminal justice system is perfectly equipped to handle these cases, or that it hasn't had its problems in dealing with them. But generally, the system appears to be quite adaptable.
And in particular, the Classified Information Procedures Act, sometimes known as CIPA, affords a set of procedures and guidelines that's been invoked scores of times successfully in terrorism cases that allows judges, and it requires close involvement of the presiding judge, it allows judges to help balance the need to maintain security against the requirement that the evidence be fairly presented.
The courts have been flexible and appropriately flexible in dealing with the admission of evidence that was obtained abroad, and that prosecutors have generally, and it certainly is a complex and difficult task for prosecutors, but they've generally been able to get the evidence in that they needed in these cases.
Well, the Miranda issue is I think, a good example of one that we concluded really is an objection that's just overstated. The scenario that gets posited is, well, what about battlefield captures? And we can't have soldiers issuing Miranda warnings. And I think our response to that is, of course, that's right. Soldiers shouldn't issue Miranda warnings. They don't issue Miranda warnings. It's a completely different context. Battlefield captures and battlefield interrogations rarely, if ever, become relevant in a criminal prosecution.
So the criminal justice system has a number of tools that allows it to prosecute people for conduct they've committed, but that is really looking forward toward preventing some tragic event, really. So in that sense, there is the ability to preempt violent incidents in the criminal justice system.